Great. Okay. Welcome everyone again back to our second training session on NHRIs and the implementation of judgments of the European Court of Human Rights. It's really nice to have you all back. We're really looking forward to having this session again and to hearing from all of you once again your questions. It's going to be really, really interesting for us. I'll just bring up the PowerPoint to show you exactly what we'll be doing today. So, as you can see from here, what we've got coming up today are the following. The first is a quick welcome from me, George Stafford, from European Implementation Network. And then we have two briefings, presentations on the basics of the Committee Ministers' execution process. The first will be from Nikos Sideropoulos, Head of Division at the Council of Europe's Department of the Execution of Judgments. You all saw him last week. And the second will be from Tamar Abazadze, Head of the Analytical Department within the Public Defender's Office of Georgia, and she'll be doing a really interesting presentation on how the Georgian Ombudsman helped use the Committee Ministers' execution process to put pressure on the government there to improve reforms on investigations into police ill treatment. And that's going to be a really interesting session, I think. Then we'll be following up with some questions. We look forward to hearing from you. There'll be a very brief intervention from me before I introduce colleagues from Armenia. That will be Mikhail Kachatrian, Head of the International Cooperation Department, and also Gohar Simonyan, the Coordinator of the National Preventative Mechanism on Implementation, both at the Human Rights Defender's Office of Armenia. And they'll be discussing a really interesting set of activities they've been doing there, where they involve not only the government, but also the NGO scene and forming alliances for implementation of judgments in Armenia. That's going to be really interesting as well. We'll follow up with a Q&A session. We'll extend that a little bit longer than the time mentioned there, I think, just so we can hear as much from you all as we can before I wrap up and we move on to the third session. So for now, I'll be handing straight over to Nikos. Nikos, do go ahead. You're on mute still, I'm afraid, Nikos.
Yes, I'm fine now. Can you hear me? No. Yes. Okay. Thank you. So it's thank you, George, and welcome to everybody. It's a pleasure again for me to take part in this webinar, which is it's a great first, as I said also last time, after many years, to try to connect again with national human rights institutions in Europe, as Council of Europe, because your role is really very important in the execution process, and you have lots of potential in this domain. My intervention actually will focus today on a few important tips on communications, on submitting communications under Rule 9.2 of the CM rules. Some basic stuff in the beginning. Under Rule 9.2 of the CMDH, the CM is entitled to consider communications with regard to the execution of judgments from national human rights institutions or NGOs. The is entitled to means that the CM actually enjoys a margin of appreciation as to whether it takes such communications into account as a matter of principle. Also, it's very important to note, and from the start, that the wording of Rule 9, paragraph 2, as to the communication content, is as follows. It says that the communication may be submitted with regard to the execution of judgments. So Rule 9 communications under Rule 9.2 actually may be, or they are broader than the communications under Rule 9.1, which concerns actually individual measures, or which may be submitted actually under the injured party. So the national human rights institutions under Rule 9, paragraph 2, like NGOs, may submit communications with regard to the issues relating to the execution of judgments, which means both individual measures and general measures, which is not the case under Rule 9, paragraph 1, which concerns communications by the injured party, actually. Now, some basic stuff about the structure of communications that you may submit to the Committee of Ministers. My basic message would be actually a 3C, as I say, message. That is, the communication should be well constructed, construction. The first C stands for construction. The second C is clarity. And the third C is concision. That should be concise, the communications. The communications should not, in principle, our advice is the communications should not be more than 10 pages. They should be very well constructed so that they're easily actually read by us and the Committee of Ministers or the delegations here. And they should be very clear from the start. For example, it's good in the introductory part of the communication that you make very clear what is the aim of your communication. Do you want to comment on the state's action plan? Do you want to propose another kind of examination, for example, from standard to enhanced, or from enhanced to standards? If you see that the execution process is going well at national level, then if you want to tackle individual measures, you may actually provide updated information on individual measures. Or you may provide information about the adequateness of measures taken so far by the authorities in order to remedy the situation of the applicant or the applicants. If the individual measures are actually dependent on the adoption of general measures, it's also very important to state that very clearly in your communication from the very start. And then you can develop actually your comments or your ideas. Now, as far as general measures are concerned, and I think there we should consider it a bit more, because I think most of the communications received by national human rights institutions are focusing actually on general measures, and rightly so, I would say, or logically so. As you know, the general measures taken by the authorities after judgment finding violations aim to prevent recurrence of similar violations. So it's very important there that you note clearly whether you think that measures taken so far by the authorities are adequate or not. And there's also a very important added value, actually, if your communications can also contain alternatives to general measures proposed or envisaged by the state. It's also very important to note that usually on many things covered by the judgments in which you may be interested in, there are many reports either by the Council of Europe or by other international organizations like the UN or the EU. And on many occasions, I have seen actually communications referring or copy-pasting actually reports made by such bodies, other Council of Europe bodies or UN bodies with recommendations to the governments concerned. Usually to repeat what other actual organizations have said are not really very useful to us. What we would like to hear from you is your own information, your information based on your own actually practice or your own experience in your own countries. It's also very important to note actually that it's very important to focus when you want to submit a communication. You have to focus on issues tackled by judgments. So try to avoid any campaign-style communications which go beyond the scope of the implementation of the specific judgment, because these are likely to be of little interest to and used by the Committee of Ministers. Broader concerns or objectives, if you have any concerns which go beyond actually the ambit or the scope of the judgment, you can always share actually your concerns or your comments with other institutions of the Council of Europe, like the Parliamentary Assembly or the Commissioner for Human Rights, who have actually a broader mandate going beyond the scope of a specific judgment you focus on. Some more technical tips, actually, which I would like to share with you for developing proposals for general measures. I would also very much advise you to start by reading carefully and analyzing the court's judgment yourself. Do not actually depend always on the analysis done by us, by the execution department. If the judgment is a pilot or an Article 46 judgment, the operative part of Article 46 related recommendations which are contained in the judgment should form the basis actually of general measures. This is also very important to note. Also, it's very important to have in mind that the character of the court judgments, the Strasbourg court judgments, is often casuistic and not contextual. So in many judgments, we have a lack of comprehensive actually analysis by the court of domestic law in practice that may indicate actually the existence of a systemic human rights problem. And I have many examples to give you where, you know, the court in a very cursory manner goes through an issue, but it's not really clear from the judgment whether this is really a really systemic structural issue, problem, or not. And this is, on many cases, the reason behind it is the judgments of the court are, fortunately or unfortunately, are very casuistic, most of them, and not contextual. Also, in many judgments, domestic law or practice shortcomings are identified in the case, in the judgment by the court in a cumulative way. So, for example, in some judgments there is 1 or 2 paragraphs where actually the court accumulates the shortcomings identified in this particular case. If you can analyze more carefully these parts of the judgment, and you sometimes can read between the lines, you can really identify some structural issues which require further attention by the authorities or by you as national human rights institution. I think we don't have much time. I would like also to note before concluding that you should not concentrate only, or my personal wish would be that you should not concentrate only on cases which are in the enhanced, the so-called enhanced procedure, but also try to pay some attention, at least some attention to the standard cases, which are not actually go through the regular CMDH meetings. If you go through the statistics, more or less half actually of the pending cases are in standard. There are around 5,000 pending cases at the moment. Around 2,500 actually cases right now are on the CM's agenda, but they are in the standard procedure. Standard procedure does not mean that these cases are not examined. They are examined by the competent ministers because the states have exactly the same obligations like in the cases in the enhanced procedure. So the states provide action reports, action plans. We evaluate these reports, and we have a dialogue as execution department with the authorities, but these are not formally, you know, go through the regular the 4 CMDH meetings every year. But I have to highlight here that in a number of these standard cases, the issues actually which arise or have been examined by the court and by us are of structural nature. The fact that they are not in enhanced procedures does not mean that the standard case does not raise structural issues. On many occasions, there have been actually classifications of cases in the beginning where we probably have diagnosed the problem as non-systemic or non-systematic, but in the course of years, you can see that this is a systematic issue. And for various reasons, you know, a number of standard cases have not been actually gone through the procedure or have not managed to put a number of such cases to the enhanced. But this does not mean that the issues are not important. There are many cases which raise very important issues. There are many standard cases which are pending for many years. So I would really advise you to go through all actually the pending cases concerning your own country. And if you really think that you have the capacity to deal also with standard cases, which are not enhanced, try to deal with them. That would be actually a great of great profit and of great use to us as well, and the Committee of Ministers. A final word just about the timeliness of your communications. As I said in my first in my first intervention last week, it will be very, very important and very useful to us if you can intervene at the early stages of the execution process. Because the national reflection procedure should, as a matter of fact or as a matter of principle, start shortly after the judgment is delivered and becomes final. So the views of your institutions may be very useful for us at an early stage in order to analyze the situation and decide on the classification of the case. So if you want also to target a case a bit later, after it has become final and after its classification, try to take always the preliminary draft list of cases which are proposed for detailed examination for the next CMDH meeting. And this preliminary draft list of cases is always issued after each DH meeting. For example, now in October, after this DH meeting, we'll publish, the Committee of Ministers always publishes a preliminary draft list of cases which are going to be examined in December, in the December DH meetings. So try to be a bit more proactive from this point of view and identify as early as possible the cases you want to intervene on. I think that's all I have to say for the moment. I look forward to the discussion a bit later. Thank you. Thank you, George. That's
great. Thanks, Nikos. Some really interesting points there. Your 3-point summary of how to of what to bear in mind when writing a Rule 9 communication of concision, construction, and clarity is a useful header that I'll pass on to lots of people who are writing Rule 9s. It's also really important to note, everyone, that the explanation of the Rule 9 system and how it works with the Committee of Ministers is further elaborated, and the introduction to it, indeed, is elaborated in the video that was sent round before this session. So that's really important to watch that if you haven't already. My colleague Agnes has written that in the chat of the group a little bit up, so I really suggest that you do watch that if you haven't yet after this session ends. There's a couple of really interesting questions coming from Emily, but I'm just going to wait before we address those until after our next speaker. So Tamar, maybe I can just bring you in. Hi Tamar, are you ready to come online? Great.
Hi, I'm here.
Gamachabat, Tamar, how are you doing?
I'm fine, how are you?
Very good, thank you. So I'm just introducing Tamar Abazadze, head of the analytical department within the Public Defender's Office of Georgia. And I'm introducing her because on the subject of using Rule 9s, the Public Defender's Office of Georgia decided to use these in the framework of a particular group, the Garibashvili group of cases, which concern the right to life and protection against ill treatment. And the Public Defender's Office managed to put pressure on the authorities through these communications on this group of cases to introduce an important level of progress. So to elaborate on this issue and this case, Ms. Abazadze, can you briefly present what was the challenge in Georgia with regard to impunity of law enforcement officers and the systemic use of torture, as shown by your research?
Thank you, George. First of all, I would like to thank organizers of these series of webinars. I think that these webinars are really helpful for many national human rights institutions attending these meetings. Just to go back to your question, it's a well-acknowledged fact that before 2012, prisoners were subjected to systemic use of torture and ill treatment in penitentiary institutions of Georgia. Fortunately, in recent years, torture and ill treatment is not a systemic problem anymore. However, investigation of such crimes remains still systemic problem. I would like to give you a clear example just to illustrate the problem. In 2013 and 2019, that is during 7 years in total, Public Defender's Office submitted 107 proposals to the prosecutor's office requesting institution of investigations into the alleged crimes of ill treatment committed by law enforcement officers. Prosecutor's office really started investigation in most of these cases. However, it should be underlined that not a single person has been responsible in any of these cases. So it's a really great problem, and according to general statistics, the number of convictions of law enforcement officers is extremely low. Even more, Public Defender's Office conducted research into the disciplinary proceedings against law enforcement officers, and our study and outcome of the study revealed that even the number of disciplinary sanctions against the employees of law enforcement bodies is extremely low. Since 2013, monitoring investigation of crimes allegedly committed by the representatives of law enforcement bodies is one of the key priorities of the work of Public Defender's Office. Annually, Public Defender's Office examines closed criminal cases, we present assessment of this examination based on the criteria of effective investigation.
So it's quite a considerable problem in Georgia, and I think
yes.
remember it was
and I would say that the main findings are that since 2013, conducting of investigation in a timely manner is still problematic. Investigations often start late, and investigative activities are conducted in unreasonably long intervals. And as I have mentioned already, investigations initiated by the prosecutor's office are protracted without outcomes for many years. Just to sum up, based in the light of legislation reviewed and the cases examined, Public Defender's Office came to the conclusion that questions arise regarding institutional independence of the investigative authorities.
So, and the next step obviously was the CM process you used here. Can you present the measures you took in this regard using the Committee of Ministers execution process?
Yes, of course. We decided to submit communications before the Committee of Ministers under Rule 9 in the group of cases, because this group of cases concerns failure to conduct investigation. So this group concerns the failure to conduct effective investigations into allegations of violations of the right to life and ill treatment by law enforcement officials. We submitted 2 communications in total. First one was in 2016. In that submission, we made an argument that Georgian legislation is not in compliance with international standards. And the main point we underlined in this communication was the fact that investigations related to torture and other ill treatments were not conducted by independent bodies. We described deficiencies of the legislation, showing that the legislation entitles law enforcement agencies to investigate crimes related to torture and other ill treatments allegedly committed by the representatives of their respective agencies. For example, if employee of the Ministry of Internal Affairs committed alleged crime of ill treatment, then it is Ministry of Internal Affairs itself which conducts investigation. And this, of course, contradicts international standard of institutional independence of the investigation established by the European Court of Human Rights. That's why in our communication, we provided recommendation. Public Defender's Office issued recommendation that our recommendation concerned the fact that Georgian government should adopt legislative amendments to the effect to establish independent investigative mechanism in order to eradicate impunity of law enforcement officers and in order to ensure investigative independence of the investigative authorities.
And what was the impact of your submissions, do you think, on the CM process and the CM decisions?
I think that the impact of this process was really positive, and this communication submitted before the Committee of Ministers was really successful, because in July 2018, the Parliament of Georgia adopted law on State Inspector Service. State Inspector Service was created in order to eliminate impunity of law enforcement for the crimes of ill treatment committed by law enforcement officers, and this was envisaged as an independent investigative body. So State Inspector's Office became operational since 1st November 2019. Of course, this is a huge step forward, but while we welcome this positive amendment with the adoption of law and creation of this independent mechanism, we underline that there are still some gaps which need to be addressed. These gaps concern legislation itself. So just to reflect, just to go back to your question and reflect what were the reflections in the Committee of Ministers decisions, I would underline that in decision, in 2017, the Committee of Ministers invited the authorities to inform the committee regularly about the independence of the investigation, and even more, in decision, the Committee of Ministers expressly referred to the concerns expressed by the Public Defender's Office and called on the authorities to take recommendations issued by the Public Defender into consideration. So this is really success. And in 2018, we already saw in the decisions of the Committee of Ministers that Committee of Ministers noted with interest the aim of the government to establish independent investigative mechanism following the consultations with the Public Defender's Office and national and other international stakeholders. So as we see in the end, this independent mechanism was established, and it was noted in last session when the Committee of Ministers examined this group of cases.
That's fantastic, Tamara, and a really interesting and good example, I think, of the impact and utility of engaging in the Committee of Ministers process. Thank you so much for that. Unless there's anything else you want to add, I think I'll move on to the questions.
No, I think I would just add that it was not only Public Defender who played role in this success, because Public Defender, together with the civil society organizations of Georgia, have been discussing the need for creating independent investigative mechanisms since 2015. For example, Georgian Coalition for the Independent Judiciary, representing 36 Georgian NGOs, pushed for the adoption of the law to this end. This coalition even prepared draft law of the draft law and presented this draft law before the Ministry of Justice. Coalition held different conferences dedicated to this issue, and different international experts were invited to take part in these conferences and express their opinions. I would say that even international actors like Commissioner for the Human Rights of the Council of Europe recommended establishment of these investigative mechanisms, and these activities were broadcasted by media. So all these actors played a role.
Yeah, that's really interesting, and it demonstrates the power of forming alliances with lots of different groups of people, not just relying on the Committee of Ministers execution process, but using that process as a broader part of a wider advocacy strategy. That's a really interesting example, and we'll be continuing, I think, with other examples of.
Yes, all actors played really important role.
Exactly. And I think that that's a really important thing to bear in mind, that sometimes in our engagement, particularly with NGOs, they might just want to send in the legal submissions to the committee of ministers, which is really important, but they're not also have a wider advocacy strategy around the cases. So it's really interesting to hear that example. Tamar, thank you so much for your intervention there.
You
I think
are welcome.
do stay around, because I think there's going to be some questions.
Yes,
There's a lot of questions, so we'll try and get through them as quickly as we can.
yes.
I think the first ones are targeted probably at Nikos. Nikos, the first question I can see here is, in case of a friendly settlement with general measures, I imagine we can also use Rule 9. Question: is there anything different that we need to take into account in comparison with a communication after a judgment?
No, the quick answer is no. In practice, the substance is the same. The obligations are clearly outlined in the friendly settlement. So one should rather carefully, first of all, of course, read again the friendly settlement and the terms of the friendly settlement, and then if there are undertakings actually as far as general measures are concerned, these should be examined by you. I mean, there are friendly settlements where there is no undertaking as to general measures, for example. There are undertakings only for individual measures. So it depends on the case. So you should go on a case-by-case basis. That's my quick reply.
Thanks, Nikos. That's really helpful. I'll move on to the next one. There's quite a few here. I'll try and get through as many as we can. The next question is from Lara Jamarauli, which is: good morning. My question is, what is the most efficient way for NHRIs to stay informed about the development of the execution of cases? Does HUDOC exec website allow to subscribe to the particular cases or countries and receive information when a new document is published? Nikos, I'll pass to you, but I'm also happy to comment on this.
Yeah, just one word. We created actually last year a special web page for national human rights institutions and NGOs, how to submit communications to the Committee of Ministers and how to keep yourselves updated. We have created also for the first time a special RSS feed system. You can subscribe to it by country or by theme, and you can be actually alerted whenever new information is online. So it's quite easy, but I suppose George can also provide some more information.
Sure, Nikos. I should say as well, in addition to that resource that's provided by the Department for Executive Judgments, EIN itself also provides a kind of a running operation where we try and inform people of developments in cases whenever we can. So essentially what we do every day is we look at the documents that have come into the Committee of Ministers monitoring process for implementation of judgments, and that includes communications from governments, action plans, action reports. And what we do when we know that people are interested in a certain case, we inform them about those new developments. And indeed, when we know that an NGO, for example, or an NHRI works on an entire country, we'll inform them, look, there's this development in this case, and then they can make a determination of whether they want to continue work on that. Do check out the resource on the DEJ site, but if it doesn't work for you and it doesn't do everything, for example, I don't think you can subscribe to updates about only one particular case. But just in any case, if you want to have that sort of service from EIN, just let us know. Drop us an email at contact@einnetwork.org. My colleague will type that into the chat, and then we can sort of set up that service for you and make sure that you're informed about latest developments. There's another question. I'll take a couple more from ICEL. Thank you for the presentation, Nico. Is it possible to submit possible ratifications to the preliminary draft of cases and suggest that some additional need to be included in the next meeting? Or how in particular can this list be used strategically? Thank you for your help and excellent presentation. Nikos, I'm not sure if you understand that question.
No, if she can she intervene orally?
Yeah, she can. ICEL K, I think it is. So if you do want to come online and just pose your question orally, do go ahead.
Hello. Yes, my question concerned that preliminary draft of cases that you mentioned, Nico, that gets published at every CM meeting, and it concerns the cases that are going to be discussed at the next CM meeting. And it sounded as though it's a good opportunity to be strategic about either following up on the cases or being or knowing which cases are going to be discussed. So I was just wondering whether NGOs or national human rights institutions can intervene and suggest that other cases need also to be included in that list and discussed at the next CM meeting, or whether you meant that it's just a good opportunity to know what's going to be discussed next time. Thank you. I hope that clarifies the question.
Yes, it's a bit clearer now to me. Now I got it. Well, theoretically, you can do. You can always propose new cases or more cases to be added. But my advice would not be actually to spend time on this because usually the agendas of the CM are very loaded already. There are more or less 30 cases actually for each CMDH meeting. And on many actually occasions, the meetings start at 9 o'clock and finish at 6 o'clock in the evening. And on some occasions, actually, we don't have enough time even to discuss properly the cases which are already for debate. As you may know, each agenda has around 30 cases for examination. But of these 30 cases, there are around between 10 to 14 cases for debate maximum. And even these 10 to 14 cases, require really lots of time. And I would really hesitate actually to add more to the agenda for the CMDH meetings. The idea for you is to be on the alert and identify immediately, the cases which are going to be examined in the next CMDH meeting, and intervene as quickly as possible if you wish to intervene. This is actually my message to you. But as I said, the most important issue for the new cases is to try to intervene at an early stage of the execution process. If you really think that there is a big issue there in the judgment, which requires intensive actually action and far-reaching general measures to be adopted by the authorities, try to intervene and provide us with information at the early stage of the execution process, if possible, as soon as the judgment is delivered. That would be really helpful. Thank you.
Okay, thank you so much, Nicholas. That's really interesting and helpful. Some of those questions I could have posed myself. Let's move on, I think, to our next presenter. I think it's really important to discuss this topic of widening the group of people who are involved in implementation. In the last example, Tamar had some really interesting things to say about how it wasn't just the Rule 9s that were used, but it was also the construction of a wider group of people to push for change on a particular case that led to success. And we're going to continue that theme now by moving slightly south from Georgia to Armenia. I'm really happy today to welcome Mikhail Khachatryan, Head of International Cooperation Department, and Gohar Simonyan, who's the coordinator of the National Preventative Mechanism on implementation at the Human Rights Defenders Office of Armenia. So perhaps welcome both of you. Could quickly say hello to everyone.
Hello. Thank you for organizing this event, and it is a pleasure to see all familiar names, but not faces. So looking forward to the continuous discussion.
It's a pleasure to have you. Ms. Simonyan, perhaps I'll start with you just by asking whether you can explain how the National Human Rights Institution in Armenia managed to ensure the commitment of domestic NGOs, which helped you in turn work out concrete proposals for the implementation of ECHR judgments.
Yeah. Probably I should start about a tool that our constitutional law of human rights defender is providing to us. It's the tool, is the possibility for the human rights defender to create adjunct counsels. In order for you to understand why these adjunct counsels are important for us, I should mention that human rights defender is entrusted with different international convention mandates, which is one of them is the NPM mandate under the OPCAT. So this big mandate needs, in order to properly execute this big mandate, we need a proper and effective cooperation with the NGOs. And this tool provided by our new constitutional law, which is quite new one, it has been adopted in 2016, provides an opportunity to create an adjunct council on different fields where different NGO representatives and independent experts can be participants of the adjunct council. This provides us an opportunity to have discussions, to have meetings, and discuss the topics that are of common concerns for both of us, because the agenda of these meetings and discussions are not provided only by the Human Rights Defenders Office, also by the NGOs themselves. And we are doing our best not to keep this very small adjunct council discussions, because not very many NGOs are included in this adjunct councils. But I can say nearly every adjunct council meeting is expanded one and the extended one, and we're offering all other NGOs in the field which might be interested in the topic or have something to share with us to take part during these meetings. And when creating the agenda of those meetings, we, or from the other hand, the NGO representatives, can offer the topics taking into account also the execution issues, because the human rights defender and many NGOs are monitoring the ECHR judgments against Armenia and their execution process. So when proposing the agenda, they are also taking into account the concerning issues at the moment related to the execution of exact or different judgments or a group of cases that can be of common interest. And usually in some cases, when we want also to make a resonance during using these adjunct council meetings, we're offering also governmental bodies to take part in these adjunct council meetings, even sometimes also the mass media representatives. I can bring just an example of recent case against Armenia, which were related to the provision of healthcare into penitentiary institutions. So during 2018, 19, and even now, there is a huge concern among NGOs and for the human rights defender related to the provision of proper healthcare in the penitentiary institutions. We proposed the topic of several discussions with the NGOs, and they also provided their experience, their individual complaints that the NGOs are getting, and we evaluated all these discussions, and this was the base of our Rule 9 submission to the Committee of Ministers. And also we have one case when the human rights defender was participating in an ECHR case as a third party. We had a third party intervention, which was based on a case when the human rights defender as ombuds institution had individual complaint. This was the Hakopian versus Armenia case, and the Rule 9 submission is the Ashot Harutyunyan versus Armenia case. When we summarizing all the concerns from the NGO representatives, came up with the issues of mainly of general nature, which are the independence of healthcare staff, their sufficiency, the medication provided there, the transfer of detained and convicted persons to the civilian hospital, which was not being executed on due time, etc. I think that we evaluate that these discussions and also taking into account the recommendations, our submissions were important because a few months after that, the Ministry of Justice came up with the draft law and changing the healthcare personnel status. The healthcare personnel in penitentiary institutions was the staff of the penitentiary institution. So their independence was a very problematic issue. Currently, the medical personnel of the penitentiary institution become independent. This is a specific subdivision under the Ministry of Justice. Nevertheless, both we and NGOs didn't stop there, because after even the medical staff of the penitentiary institutions become independent, taking into account also our recommendations, we still are facing a lot of problems in practice, because it is something for the doctors to say that you are independent You should be independent since this moment because you are not a staff member of the penitentiary institution, but this is something else that in practice they feel themselves independent, they are acting independently. That is why we are also having discussions, and we're planning discussions with the NGOs to follow up our recommendations. What have been done? What are the results? And what are those actions that we still need to do? Another important aspect of our work probably is the combined application to the submissions to the Committee of Ministers, and probably my colleague Michael will be talking about this.
Yeah, I will supplement what Guha said regarding the cooperation with NGOs. Of course, we play a liaison role between civil society and our government, and not only we are promoting the cooperation between different sectors of society. The other, the ground for intervening and cooperating in this field was the promoting the integration of international human rights standards into national legal systems, and of course the application of international, in this case European human rights standards. And the third is raising awareness and education mandate that we have at our office, at our institution. So what we did, first of all, we organized jointly with the department for execution, for the execution of judgment of ECHR, joint discussion. As Gohar said, we always invite NGOs for our capacity building and other activities, so they are always present. But this capacity building event was especially remarkable because their present aim to enhance not only their knowledge but integrate them into our work. So what we did at the end of discussion, we start to work with the NGOs to work on the joint submission. So in the case of Pogosyan, it relates to the preliminary detention as a restraint measure, and there was a problem with there was a lack of alternative measure. The grounds were not clear, and the practice was that the two courts applied preliminary detention without proper justification, and was also a problem with the length of the detention. So what was the reason to work with NGOs? First of all, they also bring their expertise and their knowledge, and also enhance the credibility of submitted information to the court, which is very important. So this kind of trainings enhance not only the awareness and joint work, not only enhance awareness among our partners, civil society, but enhance also capacity, like learning by doing, and also ensuring coherent work between different beneficiaries and interested partners, and enhance credibility of submitted information, but also make it sustainable, the cooperation between civil society and also the National Human Rights Institution, which I will also, I would like to also share with our colleagues is, beside training and joint submission, this is important to have let's say, sustainable capacity building materials for civil society and the Ombudsman Office, is to have a guideline on the implementation or execution of judgments and the involvement of these partners in this process, which I think we do with the assistance of your network. And I use also this important occasion to thank you for your work and assistance on this matter. I have all whatever I needed to say. If you have additional questions or issue to raise, I will be glad and I'm at your disposal.
Thank you so much, Mikhail. I think that's very clear, and thanks also to Gohar for your presentation. Some really interesting examples there of the importance of having a wide range of actors to be working on implementation. I want to try and involve everyone else as much as we can before we finish. So if anyone else has any questions, do go ahead and ask them either in the chat, but why not also come online as well and say hello and ask your question in person. So if there's anyone who would like to ask a question, just do go ahead, don't hesitate. My colleague Agnes is putting some information in the chat about that particular case that was mentioned, Pogosyan, and also more information about some of the resources provided by EAN. Okay, so I don't think there's any questions coming in for our colleagues Gohar or Mikhail. Any questions from anyone else about anything else that's been mentioned today? So for our earlier speakers, Nikos or Tamar, about Tamar's experience in using Rule 9s, or for Nikos about the functioning of the ECHR implementation system. Okay, we have a question from, sorry, Nikos, there's one question coming in, but do you want to speak first? Okay.
No, later.
I'll go ahead now. We've got a question from Leonie. Thank you for this presentation. I was wondering whether you have made some joint efforts in other cases. So I think that's directed at Gohar and Mikhail.
Yep, this was the first joint submission to the Committee of Ministers, but nevertheless, we had 2 more submissions to the Committee of Ministers and 1 third-party intervention. During all these interventions, we took into consideration, because previous to this submission, we had discussions with the NGO representatives, and their ideas and recommendations were included. Nevertheless, the Pogosan is the first joint submission, but I'm pretty sure is not the last one.
That's good to hear, Gohar. Maybe I'll hand back to Nikos. He wanted to say something.
No, I just want to highlight actually something that you also mentioned earlier, that communications under Rule 9 are not the only means for improving human rights situation on the ground in your countries. That's one of the many tools that you can employ, and I'm very happy to hear that most of you actually are engaged in various national councils or bodies actually which deal directly or indirectly with execution of judgments through the adoption of general measures, legislation, or other measures necessary. So I just wanted to highlight that it is very important that you do this proactive work in a synergetic manner with your authorities. And whenever actually you advise your governments to do something on a general level, try always to inject into your thoughts or your comments also what the judgments of the European Court have said, and what the authorities have done so far in order to execute the judgments. Also, I would very much encourage you also to engage in more training of professionals like law professionals, legal professionals, lawyers, judges, prosecutors. There is a huge capacity there for national human rights institutions. I know that many of you are very much active in training of law professionals. But there, I think there is much more to be done, and in a much more systematic manner. Because I just want to highlight once again that the execution of the judgments do not happen in Strasbourg. The execution of the judgments happen in your capitals or in your own countries. So if those professionals are not adequately trained and adequately informed, changes are not going to happen anytime soon. That's for sure. Thank you.
Actually, thank you very much for raising this issue. We were thinking about that, but we want to maybe, we feel like that Council of Europe help tools could be useful in this regard, because we should have fundamental materials or the courses elaborated already to conduct occasional trainings for those legal professionals. So we were thinking to ask the Council of Europe and use these help tools in order to organize massive trainings for the respective professionals. Thank you very much.
That's interesting, Mikhail. I think there was a question maybe from Tamara. I'm not sure if she meant to come online. Perhaps not. I think that was perhaps she was just entering the room and turned her microphone on by accident. Okay, I think that is all of the questions that have come in today, and I think it's probably a good position for me to just introduce the next 2 sessions that we're doing. A good segue is indeed from the last thing that Nikos raised, which was this question of where does implementation happens? It happens at the national level, not in Strasbourg. So that's what the 3rd session will very much be devoted to discussing. We'll be giving a little bit more information about how you can assess the overall level of implementation in your own country. Nikos mentioned the high number of standard cases that are pending. We'll be giving you information about how to look at those statistics and to understand exactly what the overall picture is like in your country, and use that perhaps to put governments not under pressure, but hold them to account about their record. We'll also be having presentations from people who've had dialogue with their government authorities, and the best way to do that, using an example from Croatia, which is quite interesting. And finally, there'll be a little bit more information in that session about the alliances that have been created in a different example from Greece. So that's the third session. The fourth webinar will be devoted entirely to the Committee of Ministers execution process, the implementation monitoring process in Strasbourg. So I'm sure lots of you will have questions about that, and that'll be a very interesting session as well. But for now, I'd just like to wrap up this session by thanking all of our speakers, Nikos, Tamar, Gohar, and Mikhail. Some really interesting points being made there, and I thank you very much for your time. We really look forward to seeing those of you who will be joining us for the third and fourth sessions. That's the core group, as I understand it. So until October, I wish you a very good day.